Hey guys, this is Tanyé. And today I am doing another video. Yes, and this one is still about those land patterns and getting a deeper understanding of all of the ins and outs of why there were land patterns given out and what it should mean to us that have lineage to any of the tribes here in North America, in specifically the borders of the United States. So I am going to go ahead and get some music going. I am sorry I took so late. I was going to do it yesterday. I just was so tired and I had worked all day. I just could not get into it. And today I also had a lot of things that I wanted to make sure that I included in this video. So it took me a lot of time to get my thoughts and everything clear how I wanted to go over some different things in here. So before I get started here, let's go ahead and play that intro. And I think I'll play a couple of songs after, and we'll get started.
Yeah, I don't know everything. Nah.
What do I look like, an expert?
But I'm gonna tell you what I do know. You are invited to subscribe, share, like, and thumbs up this video. And enjoy another episode in this series. Keep coming back, because we do this weekly. Go to Tanyé So Official for the latest updates and merch for our followers.
Okay. I know I played enough music for tonight. So let me go ahead and get into this because I said that I was going to go ahead and read the rest of that article from this website, and I definitely want to share my screen so you guys can see it. And okay, now we're talking about understanding land patents and how they work. And I'm going to read through some of this. And this website is teamlaw.net, and it has some good info on it. There's more for us to know about it, right? because we need to secure these land patents. There's been much talked about in relation to land patents lately, as far as most of the, hold up, did I share my screen? Oh, okay. I tried to share it and it didn't show up. So how about I share another screen right quick before we actually read through that article, because I want to keep it in our minds what our ancestors said about this very situation and what we as individual family members need to do and come together with our own family and reclaim land patents that we might be connected to, and also talk about the patents that the freedmen, and compare the land patents that were given to the newly freed slaves compared to the other patents. So anyway, let me go ahead and do this sharing of my screen. Hopefully everybody's going to be able to see it. Is it coming up? Is it coming up? Is it coming up? Can you guys even see it? Okay. All right. All right. So let me go ahead and play a little bit of this. Fair use, everybody, fair use. So here we go. Now I know I pushed play. I know I pushed play. Let me try this again. I tell you what. Come on, YouTube.
At the very same time that America refused to give the Negro any land, through an act of Congress, our government was giving away millions of acres of land in the West and the Midwest, which meant that it was willing to undergird its white peasants from Europe with an economic floor. But not only did they give the land, they built land-grant colleges with government money to teach them how to farm. Not only that, they provided county agents to further their expertise in farming. Not only that, they provided low interest rates in order that they could mechanize their farms. Not only that, today, many of these people are receiving millions of dollars in federal subsidies not to farm, and they are the very people telling the black man that he ought to lift himself by his own bootstraps. And this is what we are faced with, and this is the reality. Now, when we come to Washington in this campaign, we are coming to get our check.
So you heard the man. You heard the man. You heard what he said. He said that all this land was given out to settlers coming over here, and it was taught in schools to how to use their grants and financial planning and all of these things that caused them to have so much resources and generational wealth. And so that is something that we need to remember, is that we need the same thing for us, these land patents. Now, I have seen some good information coming from this website, because it gives me us some insight on exactly what these land patents are for and how they can help us. And apparently this group of people that have created this team law, they want to share, want to find out I guess, who the electoral college are, members of the electoral college are. So they feel that the electoral college can help elect better leaders and restore the republic outside of the democracy. So anyway, let me just go ahead and read through some of this. There's been much talked about in relation to land patents lately. As far as most of that talk goes, I'm glad people are talking about them. It's about time. The problem with land patents is ignorance. And the worst thing about ignorance is most of the people providing information about land patents gets the information from other marketers that know little to nothing about land patents or their effects. Thus, most people have almost no accurate information or knowledge about either the nature of land or of the land patents from which their rights to the land come. Still, some say the only bad news is no news. We disagree. Inaccurate or misleading news is worse than no news because it really can mess somebody up and land them in the slammer. To that end, we published this article to help eliminate the inaccurate and misleading so-called information about land patents. It seems that most of the people in our nation today either have no idea what a land patent is, or they think it's a good way to swindle or otherwise avoid paying a bank or tax collector some amount of funds. The simple truth is a land patent is merely a land grant made patent, which is to say some sovereign government's chief executive, king, president, signed a land grant from that government and sealed that grant by making it patent permanent, forever, irreversible, respectively. Though the land patent is the title to the land patents do not limit your right to contract. And that means land patents do not limit your ability to secure your contracts with the property pertinent to that sits upon or is related to. That's what appurtenant means. Your land as collateral securing your promise to pay. People also think that they own their land because they paid for it and they have a warranty deed. However, often that is not enough to establish land ownership. Though it is true, land protected by land patent can't lawfully be seized for debt or taxes. Therefore, no mortgage or tax liability stand against and secured by a land patent. However, most people do not understand what land patent secured land is. Therefore, it is important to remember that the term land, as it is used in relation to land patent secured land, is synonymous with dominion, which is intangible, and it is a distinctively different thing from the tangible property pertinent to the land. Further, the land patent does not limit people from their right to contract. Thus, the land will not limit the enforceability of your subsequent agreements or your respective obligations thereto related. Furthermore, even if you could hide from your obligations behind the land patent, that would not be likely the best way to go. Team Law is promoting itself, saying they can likely help you discover far better ways to resolve any legal problem equitably. Historically, we live in a nation that hasn't had elections in its central government since before 1917. I will have to look that up to verify that. The states individually stopped electing government officials at least by 1971. The main cause of this was electors were either ignorant of their responsibilities or parts of the national takeover. The main cause of that was the people forgot about their actual land patents and the chain of title to them, and accepted title insurance instead, which is an abstract is a document that contains a summary of basic information extracted from all the transfer documents used in the chain of title to assign title to land from the patent to the present. Okay, some ignorant people will tell you land patents don't work. What that means is they don't know how land ownership works. They speak from their ignorance. The truth is in their document, land patent itself, where its term duration of authority is expressly found as an element of treaty law, the duration which is forever. For those who have tried land patents unsuccessfully, the cause for their lack of success is ignorance. Respectively, it is time to put the ignorance to rest. Okay, so they say, think about it. Where did the land within the United States of America come from? Now, this is a very good question. And knowing our who and knowing this, the answer to this question is really, really important, and knowing the history behind it and how some of these land grants came into play. It came from England, France, Spain, Mexico, Russia, Hawaii, and from the Native American Indians. How did the United States acquire the land? By purchase, like the Manhattan Island, or the Louisiana Purchase, which if you ever heard anything about Empress Verdiasi of the Washita tribe, she talks about the land patent for the Turner family and the Louisiana Purchase, and how there's 68,000 acres of land of her family's land that is in a land grant. Anyway, and Alaska, by war power, like with Hawaii and much of the Native American Indian lands, by treaty, like the Northwest Territories Treaty, the Guadalupe Hidalgo Treaty, and by treaty as the end result of war, like the Revolutionary War for independence from England. The end result, regardless of how the land was acquired, a treaty was ultimately designed whereby the land was resolved and reserved for the proper possession and individual ownership of people of the United States of America. Security in land rights was and is found within the treaty. Once land was acquired in the nation, it was held by the United States until someone provided their claim to it. Once the land was properly claimed and filed, the General Land Office certified that the surveys were paid for. According to the various land acts of Congress, the land was then made patent under the signature and seal of the President of the United States of America. When a state enters the Union of the United States of America, an enabling act is agreed to. The enabling act requires that all of the unappropriated, unpatented lands be forever granted to the Union for its disposition. For example, here is an irrevocable ordinance from Colorado's Enabling Act, that the people inhabiting said territory do agree and declare that they forever disclaim all rights and title to the unappropriated public lands lying within said territory, and that the same shall remain at the sole and entire disposition of the United States. Without such transfer of control over the right to title of the land, there would be no effective authority in a land patent sealed under the signature of the president. For example, with few exceptions, US of A, land patents have no authority in the Republic of Texas because Texas never ceded its land to the United States. Of course, Texas has land patents as well. It is just that they are granted and signed by the governor of Texas. That's good to know. Once the land is placed in trust under the sole disposition of the United States government, it stands there until someone makes a proper claim for it. And because the Constitution forbids the United States from owning it, they must grant it to the person that proves their proper claim to it. That is when the land is granted to the proper claimant, and that the grant is made patent under the hand and seal of the president. Notice the net effect of these enabling acts in relation to state taxes and state statutes. After exclusive jurisdiction over lands within a state have been ceded to the United States, private property located thereon is not subject to taxation by the state, nor can the state statutes enact subsequent to the transfer have any operation therein. So they're saying that when it becomes private property, and with a land patent, it's that person not, or that person and their heirs and assignees, and not the state or the United States. As after exclusive jurisdiction over land within a state has been ceded to the United States, 1830, private property located thereon is not subject to taxation by the state, nor can the state statute enact subsequent transfer of any operation therein, 1832. Did it basically, it repeated itself. Okay. Every state within the United States Union of the States, with the exception of the Republic of Texas, granted their unappropriated lands to the disposition of the United States as a condition of statehood. Then, as people acquired land under the various acts of Congress, the president signed the patents securing the patented rights to the patent holders and their heirs and assigns forever. And there are many more cases where the United States Supreme Court has supported the fact that the land patent certifies absolute and supreme title to the land. There are no cases where the courts ever ruled against the properly obtained land patent. Sumner Corp versus California 466 US 198 is not listed above, yet it is one of the best cases describing how land patents work. In that 1980s case, the court noted that they had ruled, and they were not going to rule again. The land patent is supreme title to the land. The case was one where California was granted the Tidewater lands in the California Republic Constitution, and therefore California went after a family's land, which land was secured under patent on an old Spanish land grant. Interestingly, the case didn't talk much about land patents. It talked about the Guadalupe Hidalgo Treaty. Imagine that, a land patent case that speaks mostly about the supreme clause of the Constitution, which clause states that treaties are supreme law even over a state's foundational constitution. Do you get it? Here's how land patents work. 1. The land was originally acquired within the United States of America by some treaty. 2. Your land patent secures the rights of the treaty upon which the land was originally acquired within the territories of the United States from the treaty to the individual person named on the patent. The patent specifically grants the described lands to the party named on the patent and to their heirs their assigns forever. The land okay, I think I'm on number 4. The party named on the patent then passes the inheritance, grants, or assigns to the patented lands to someone else, which heir or assignee is now named on the patent by that assignment. The documents that demonstrate such an assignment are often called deeds. Because the grantor cannot compel you to accept the assignment, it is necessary for you to take some action to signify your acceptance of the assignment. For this reason, we use team laws, copyrighted declaration of land patent. Once you have accepted the proper assignment of the land patent with proper documentation, you are named on the physical land patent where it says, and to his heirs and assigns forever. It does not matter how many times the land has the land is reassigned. The patent by its own creation lasts forever and belongs to the named party and to the heirs and assigns forever. So what do you do to secure your land patent? It has this little link right here. And then it talks about some more stuff. And let's go ahead and read some of it. We present the following in hope that you will educate yourself with the truth and prepare yourself to stand as electors, as our forefathers and the founding fathers of this nation did, with your land and liberty and rights intact. Though there are many purveyors of information about land patents on the internet, most of the purveyors mix fact with fiction regarding the use of the same, implying nefarious purposes for the use of land patents. The simple fact remains through it all. The land patent is the title to the land, respectively, given that in the terms of said founding fathers, an elector is by definition a landowner. This article is about Team Law's land patent sandwich service. So they are promoting this land patent sandwich, which service we provide for the sole purpose of discovering who the electors are, so we can help the people restore our original jurisdiction government back into their vacant seats to save the nation. The land patent is the title to the land and initially to the property pertinent to the land. By definition, a land patent is the only form of proof of absolute title to the land in the United States of America. A patent is the highest evidence of title and is conclusive as against the government and all claiming under junior patents or titles. And then there's U.S. versus Stone to U.S. 525. The patented grant of land is a public law standing on the statute books of the state and is noticed to every subsequent purchaser under any conflicting sale must made afterward. Okay. Congress has the sole power to declare the dignity and effective titles emanating from the United States, and the whole legislation of the federal government in reference to the public lands declares the patent the superior and conclusive evidence of legal title. Land patents are granted to the named party and to their heirs and assigns forever. So anybody else that they think is a good friend that they want to be included, they can add them to their patent, or could have. Therefore, to secure ownership of land, you must have the proper chain of title. Okay, so we got to have the chain of title, guys, that secures your land ownership to a properly assigned underlining land patent, or you could lose what you thought was your land in a land contest. The following steps are steps we follow to secure documents to accomplish this. We use our copyrighted forms, which we cannot publish here because there are so many unscrupulous and ignorant people that would use these forms incorrectly and thus possibly jeopardize the process. Therefore, our forms are only available from Teen Law directly. So it's still talking about what they do. And so, but there's still information for us to know about this. First, as a landowner, we must have evidence of our right to the land. That is to say, a warranty deed, a well-supported quitclaim deed, a legally and lawfully documented assignment, inheritance, etc. In any land rights battle, the complete chain of title is necessary to a sound win. So for our own records, we always secure the entire chain of documents from the patent, the title itself, to the present. Such a chain of title perfects the title. Though the only way you can be sure that you own the land is to have a complete chain of title in your own records. If you are sending documents to Teen Law to use Teen Law's land patent sandwich service documentation, we do not need the complete chain of title. Okay, so I don't. Okay. Second, find the land description on your right to the land, your deed, and get it into land patent form. Okay, find the land description on your right to the land, your deed, and get it into land patent format. In the original 13 states, land descriptions are usually made by describing landmarks with meets and bounds, which is where a description starts at a known point, then describes how far to go in each direction until the body of the land is described. That method is difficult to deal with over time because landmarks can change, move, or disappear. Therefore, in those 13 states and in Texas, we need to see certified instruments that show your land is physically located within the boundary of the land patent's land description. Virtually all of the land in the rest of the constitutional republic was mapped in section, township, and range format. STRF, the acronym, I guess. If the land description on your land, if the legal description of your land on your right to the land documents, hereafter warranty deed, okay, is not in STRF, then you need to get it into that format to find the proper land patent for your land. To do that, you will need to trace the legal description on your warranty deed back to the STRF. For example, if your deed says Lot 3 of the Byerton subdivision as recorded in the Dexter County land records, then you go to the Dexter County Clerk and Recorder's Office, okay? Dexter County Clerk and Recorder's Office. So County Clerk and Recorder's Office of whatever county, and find the original copy of the subdivision's plat map. So we're looking for plat maps. Find your lot and locate the section, township, and range that includes your lot. Get a certified copy of the county plat map of the subdivision your land is located in. We always get 2 certified copies of everything. Then we keep the documents in 2 separate places for security's sake. You'll especially need the part that legally describes the land, okay? Then that part is called the legal, and it almost always lists the land description in STRF. While your land described on your deed is within the land described on the respective land patent, that can be done with certified official plat maps, or you can contact a certified surveyor familiar with creating official plat maps. If you have difficulty with this, you may contact the legal team laws forum and send a private message to the admin. So maybe get in touch with them if you want some assistance. I haven't used them personally, and I'm not giving anybody any legal advice. I'm just reading what it says and putting the information out for educational purposes. If you have a trust deed or no warranty deed, you will also want to contact some help for some help with that. Third, the description of your land in STRF. You're ready to go acquire a copy of the appropriate land patent for your land. This is done by taking the legal description of your land in STRF to the Bureau of Land Management and asking them in their land patent records office for a certified copy of the land patent for the land represented by your land description, including section, township, and range. It's a good idea to get at least 2 certified copies of the appropriate patent and a copy of the patent plat map. But I think that you can order them online these days. I don't know when this was written. Now that you have certified copies of your land patent and certified copies and or originals of your warranty deed, you're ready to send your documents to Team Law for completion. And they say that they compile them all together. But let's see if there's anything else that we need to put in here. Read from here. 5th, when you get the sample land patent sandwich forms back from Team Law, they are designed to be used for your educational purposes to inspire you to generate any final documents you may need. The package that returns to you all of your documents contains a cover letter that shares with you how we would sue such forms. When you are ready to record what you need, you will need a notary public to date and sign your documents as needed. And it doesn't give any the land patent sandwich that they're talking about. It comes with no legal or educational support. As noted above, we provide the service in order to find landowners so we can help people reseat our original jurisdiction government. Okay, so 6th, you need not publicly file any records of your land patent. It is what it is and cannot be changed, updated, or negated. However, most people prefer to protect their land interests with public filing of at least a properly executed instrument like the sample copyrighted quitclaim deed provided in the land patent sandwich documents. Such a public record of your ownership interest can resolve allegations from anyone alleging they have an ownership interest and can resolve statutory race to the court issues. If you wish to make a public recording, there are several methods you may use. Maybe you can use all of them. I guess. But file it in the clerk and recorder's office with the land records of the county. Make public notice that you accepted the assignment of the patent in legal notices in a local newspaper. Post the land patent sandwich on the county's public notice bulletin board, usually found at either the county district courthouse or at the sheriff's office. Post office bulletin boards may also provide sufficient notice. So this is in a nutshell what they are saying you need to do. Again, that website is teamlaw.net. So you can check them out and see if it can be helpful to you. Now, a couple other things that I wanted to just mention. It's like 45 minutes into this broadcast here, and I really wanted to just talk about some other patents of the freedmen, in case your family is associated with them, and the difference between the patents that we saw on part 36 and a half, the land patents that we looked at there versus the ones that that we see on okay, here we go, on here. And let me go to the allotments. Where is it? This is our shared family history.com. I think they did a great job getting a lot of information in here. One thing that I wish that I would have been able to see is the other side of the Stevenson family on here. A little bit more about Hardy Stevenson and other family members. It's got some family members, quite a bit, but I feel like it could have it can be expanded, especially if some people know. Okay. I don't know if I can make this any bigger, but here is one of these patents, and let's see. Okay, so whereas by the act of Congress approved July 1st, 1902, and ratified by the citizens of the Choctaw and Chickasaw Nation September 25th, 1902, it was provided that there should be allotted by the Commission of the 5 Civilized Tribes to each Choctaw and Chickasaw freedmen, and equally in value to 40 acres of the average allottable land of the Choctaw and Chickasaw nations, which shall be inalienable during the lifetime of the allottee, not exceeding 21 years from the date of certificate of allotment. And whereas the said commission of the 5 civilized tribes has certified that the land hereinafter described has been selected by or on behalf of Millie Williams, freedmen, as an allotment. Now, therefore, we understand that the principal chief of the Chickasaw Nation and the governor of the Chickasaw Nation, by virtue of the power and authority vested in us by the 29th section of the Act of Congress of the United States, approved June 28th, 1898, have granted and conveyed, and by these presents do grant and convey unto said Millie Williams all right, title, and interest of the Chickasaw and Choctaw nations and all of the citizens of said nation in and to the following description of land. So it gives the description of land. Let's see. 40 acres or more or less, as the case may be, according to the United States survey thereof, subject, however, to the provisions of the Act of Congress approved July 1st, 1902, and it has the witnesses of the Department of the Interior and the governor of the Chickasaw and the Choctaw tribes. So what we see is that this one doesn't say anything about your heirs forever. And it also gives a 21-year limit to when they can make good on bringing on this allotment. Maybe 21 years after the death of the person, unless it's properly, I guess, redeeded to the children. It's a little, I'm not 100% sure on how that is broken down. I know that some people still have theirs, but what I don't understand is if many of them were on the 1900 census records, why they have to pay property taxes on this land. And I also wanted to mention that in the form of, reparations, and if people are not connected, to any of the patent holders on the BLM website, can they also get, as far as reparations go, get these redeeded properly like the other land patents that everyone else seemed to get? I'm just wondering what can be done about that. But I also wanted to mention that, there has been talk about and evidence, I guess scientific evidence, that people have found about, ancestors, Egyptian, or actually we should maybe call them Kemetic, that's probably what they call themselves, ancestors having cocaine and tobacco and what you call it, they got some fake mummies. This is one that I didn't read the article to it yet. Psychedelic mushrooms, and what else? There were some other things that were said to have been found in the mummies' follicles and all of that after they were digging these people up and parading them around in museums and things like that. And the reason why I even bring this up is because maybe some people get into these blocks when they're doing their genealogy. I know that I have at this point. I've gotten into some blocks regarding like birth and death certificates of certain ancestors, key ancestors, linking me back to these land records. And while it should make us upset that people are, digging up and poking and prodding these ancestors, maybe there are some other ancestors that we need to be poking and prodding. And the reason why I'm bringing that up is because there's actually some really good articles. There's one more article that I'm going to just share here from this other website. Which one is it? Please like and share, like and share. If you made it this far in the video, you are awesome, baby. You are awesome. Is it this one? I think it is. Yeah, this one. I just want to read this first, maybe 2 paragraphs. The recent findings of cocaine, nicotine, and hashish in Egyptian mummies by Balbanova et al. Have been criticized on grounds that contamination of the mummies may have occurred, improper techniques may have been used, chemical decomposition may have produced the compounds in question. Recent mummies of drug users were mistakenly evaluated, that no similar cases are known of such compounds in long dead bodies, and especially that pre-Columbian transoceanic voyages are highly speculative. These criticisms are each discussed in turn. Balabanova Balabanova et al. Are shown to have used and confirmed their findings with accepted methods. The possibility of the compounds being byproducts of decomposition is shown to be without precedent and highly unlikely. So they're saying that because of decomposing, it's highly unlikely that this stuff is faked. And the possibility that the researchers made evaluations from faked mummies of recent drug users is shown to be highly unlikely in almost all cases. Several additional cases of identified American drugs in mummies are discussed. Additionally, it is shown that significant evidence exists for contact with the Americas in Columbian times. It is determined that the original findings are supported by substantial evidence despite the initial criticisms. Okay, so I just wanted to go over that just because, all those people that, want to talk about being Kemetic and black, which means black lands, I guess, in Kemetic language, then you can also be American, indigenous Americans too. So that's another key thing that we want to keep in mind. But I wanted to say that there are, it led me to another question because I had some blocks in my own genealogical search. And I know that I'm doing this video because I want us to really be able to see the hijack. Now, this woman here, to me, she looks like a black woman, or what we call the so-called African-American, so-called black person, right? So Sally Imahota in Manor, Chickasaw Colbert, okay? Just showing that she is Chickasaw, okay? And apparently her father was British, her mother was a Chickasaw. She looks like a black woman to me, like comparable with somebody like what's that lady's name? She reminds me of Tootie. She played Tootie. I don't remember her name right now, but Tootie. And so some people don't have birth records, especially when and also with their age, I guess, or the claiming of by the father on their wills and all of those kind of things. So there are these blocks that people have, but there are many slaveholding families when it comes, and I'm specifically talking to those people that have done their research to the freedmen rolls, and many of these people are, just told that they were the slaves of the actual Native Americans, but we just found or figured out some information about the Kemetic tribes that were over here that or were doing trade back and forth. And if they're doing that over a long period of time, that makes me also wonder how many mixed in with the population here. And there's even more information about the Moors and how they were coming back and forth, and I really haven't gotten a whole ton of information about it. I just know it happened in 7-Eleven, and they have been coming and trading back and forth and mixing for years, centuries before the Europeans figured out that the Americas were here. And with that being said, I asked another question. This other question, I just put it in Google, because some of these slave masters, they have bones, and we haven't dug up their bodies. Maybe we should, though. Maybe we should. And would it be okay to just get a sample? They've been sampling and parading ancestors, our human ancestors around like pets, or like in zoos, but instead they're having them in museums and taking them from their rightful homelands and putting them all over the world, and not letting these ancestors rest in peace. Well, maybe a few people can not be so rested in peace. And so I just asked Google, can bones be DNA tested? Any body tissue that, and this is what it told me, any body tissue that is not been degraded is a potential source of DNA. Bone is one of the best sources of DNA from decomposed human remains. Even after the flesh is decomposed, DNA can often be obtained from the demineralized bone. And good question here is, how long does DNA last in bones? A study of DNA extracted from the leg bones of extinct moa birds in New Zealand found that the half-life of DNA is 521 years, which is less than 466 years that people have been saying that so-called Black people have been enslaved. So every 1,000 years, 75% of the genetic information is lost. After 6.8 million years, every single base pair is gone. So I just wanted to put that birdie out there, because guess what? With the records being so tremendously mixed up, and not enough information is out there like that, but there are those slave holders that keep on popping up in my family tree, and I'm sure other people's family trees. And we need to know, were they truly the fathers or not, to help us get these secure these land patents and our rights to them. Or they can be simple and find some other land that hasn't been patented out and give us some allodial deeds, or change these deeds of the freedmen to allodial ones, like they gave the European settlers, because a lot of land patents are related to European settlers too. Just so people know, because they've been on this a little bit longer than I've heard some of our activists and teachers and scholars within the Aboriginal and indigenous community. So anyway, I just wanted to put this stuff out there, see what you guys thought about it. Please leave a comment and subscribe to the channel, like it, share this video. I just wanted to build with other people and get information that I found out there and grow with people of like minds. But I'm gonna go ahead and get out of here. It's been an hour, so I'll see you in the next video. And yeah, I'm gonna leave the same way that I came in. All right, y'all have a good night.